And also to make it easier for those that do not have access to watch us live, we can also post this on a Facebook page. But for now, I think let's just run with this on this platform without making it too complicated, right? But should anyone have a challenge in connecting, then they can join us they can join on the Facebook, and we'll be able to see the deliberations, and they can also ask questions and do all sort of get all sort of information. Okay, share. I'll share my timeline. Okay. Okay. It's preparing to go live on the Facebook page. Right. Okay. All right. Yeah. Now let's get started. A very good evening to everyone who's joined us. A special welcome from me. I am Victor Sibeko, the convener of this webinar, In Conversation with Victor Sibeko, but I don't want to steal the thunder. The reason why we're having this conversation tonight is because of a special project that started last year. Some of you may remember Khabula Church, a church that was established and it started running from a shebeen or a bar. Walter and Lucas are joining us from Meadowlands, Labro Cafe, which is a bar. Normally on Tuesdays, the bar is closed. So there was an immediate need to do something about this day and don't put it to waste. So what we're doing now, every Tuesdays, we're having conversations with men, trying to build our nation one man at a time. But this time around, this topic warranted that we all have an in-depth conversation about the wills, the last will of testament. That includes trust. When the suggestion came through, we then filtered this program onto our in-conversation sessions. Now, I'll be facilitating or moderating the conversation. We've got two special guest speakers whom I will introduce soon. But before we get started, on online meetings, I know I may be preaching to the converted. With online meetings, please keep your microphone muted at all times so that you don't disturb other people by picking up background noises. And the background noises could be the child, it could be the wife screaming, or it could be the husband screaming. It could be a car hooting outside and many other noises. So if you would like to you'd ask a question, if you master Zoom, you can find a little gadget down there. You can raise a hand and we can see you that you've raised a hand. Then we can you can field your questions. But what I would like us to do is let us listen in, and then we'll stop. We'll open up for questions. We'll open up for engagements. We'll also present and then stop. Those of you that might want to comment and share their experiences are more than welcome to do so. Now those are the house rules. Let us respect everyone's opinion. Let us respect every presentation. And to our guest speakers, thank you so much for making time available for us. It is valuable. But before I start, I would like to share a quotation which I found so much relevant to this conversation today. And it says, I quote, "A will is not just a legal document. It's a love letter to your family, ensuring their well-being and security after you are gone," unquote. Very strong. A will is not just a piece of paper, or it's not just a document that you put together, but it is a love letter to your family. Because today, we even have child-led families. We even have feuds, fights. Imagine a TV program called Gugitila, people fighting over property, people fighting over what they loosely call a family house. And the reason why you'll end up with a family house that does not have a rightful single owner is because there are no clear instructions left by the rightful owner of the property or rightful registered owner of the property. So before we pass on, we need to ensure that we have left that love letter. Now, this webinar this evening is all about assisting all of us to have an understanding as to why is it important to have a will. It is no wonder or no surprise why it's called the last will and testament. And within the last will and testament, there's a lot of other things. And some of those things that are in there are things like trust. What if you pass on and also have children that are still underage? Those children cannot be allocated money per se, but the money can be put into a trust. And this trust will look after the children when they are at the right age. Now, I'm no expert in wills and trusts and properties and the works. Today, we are joined by people who master and understand these aspects, these critical aspects. And in our midst, I'm delighted to introduce to you Advocate Mxolisi Mugwena, aka Indoda Ongayethemba. He's a very special brother, a colleague, a friend, who is an advocate. I tell you what, you ask him something, he represents you. It doesn't take too long for you to find the answers in terms of what you need. I will allow him later on to introduce himself because I will be doing injustice to say who he is and what he does. Over and above that, we've got one of our own from Ekasi Lamakasi, Lucas. Lucas is into property, and he has just completed very interesting modules. Amongst those is wills and estate, property law and conveyancing, civil litigation. And he also understands all the 2T and all the legal things that go along with the administration, because when we are gone, we leave a mess. And the mess we leave puts our loved one into a messy situation and a murky one where there's chaos. And if you do not have a will, I will leave it to the experts to tell us what happens. Now, to call upon one of our guest speakers to briefly tell us who you are. I know I've introduced you as Lucas, but tell us Kuti Ubani, Wenzani, and how do you go about doing what you do before we get into the crux of the matter? And I'd like to start with you, Brother Lucas.
Good evening. Good evening, good people. Can you hear me?
Yes, we can.
Hello, good evening.
I can hear you. I can hear you, Brother Lucas. I'm sure everyone else can hear you.
Good evening, good people. My name is Lucas Letsholo from Soweto in Pilani. Yes, as Mr. Sibeko has touched up on my background, it's true. I don't like to repeat what someone has said about me because already the platform have been paved. But yes, I have practically I'm a property practitioner. You can say it's an estate agent. And then when coming to qualifications, property law and conveyancing, civil litigation, administration, and wills and estates. So today I'm prepared to share more with you about wills and estates. But it doesn't close a chapter where if you also want to ask about other fields that might benefit you today, my doors are open to can share with you. Thank you.
Thank you so much. So, ladies and gentlemen, what we will get more from Lucas is on issues relating to properties. We know the feuds and the fights, as I said. Gugitila, people are fighting for that. What happens? And what happens when you pass on and you have a property? But when things get very murky and dirty, now you need a representative. You need someone who will be able to represent you and get you out of the mess. We are joined none other than Mxolisi Mugwena, Advocate Mxolisi Mugwena. And for now, Indotonga Itemba, I'd just like you to introduce yourself and greet Izindwendweze to our guests. Mr. Mugwena.
Good evening, brothers. My name is Mxolisi Mugwena. I am originally from Katohom. Grew up there, attended high school in Katohom, and I went to boarding school in Limpopo due to the upheavals in the township. Then I attended University of the North, commonly known as DEVLOP. Then later, first and presently I'm an admitted attorney. I'm an admitted advocate of the High Court based in Pretoria. My chambers at Echudo Chambers at Church Square in Pretoria. I am delighted, brothers, to share the knowledge that I have pertaining to the administration of disease estate that includes that is going to include testate and interstate succession. I will explain those terms as we go by. I am delighted to be on this platform, and I'm looking forward to be with you forever and ever because we are brothers. I want us to cap the problem which emanates from our townships, whereby a number of people uh, die interstate. When I say interstate, without leaving a will behind, and then it becomes a problem for the children and the wife that is left behind. As we know in our townships, whenever a brother or a sister passes away, we tend to believe that as a brothers, we are entitled to that estate. So in order to curb that problem, it is very imperative for us to have to draft a will and put it forward with our attorneys so that it can speak for us the day we are unable to speak. Thank you very much.
Thank you, Mr. Mugwena. Before we get started, I've already heard about the will, the trust, the estate, and now we're talking about somebody dying interstate. During this conversation, a lot of terminology is going to pop up. Perhaps before we get started, so that you understand exactly what we're going through, and in your own space, you can also make notes. We will be talking about the will, the estate, the assets. We will be talking about the executor. What is an executor? We'll be talking about beneficiaries. We'll be talking about guardianship. So in your own space, in your own time, you can just make notes. But what I'll also do, I'll also throw some of these terminology onto the chat group. Now, let's start with you, Bra Lucas.
Yes.
In what you do and being in the estate. I want this conversation to be a bit disruptive, purposely.
Okay.
The type of challenges that you have when you have to start dealing with someone's property, wills and estate, in terms of the property laws. What in your explanation in the property space, when I say I want you to sell my house, and then you start asking me questions which will pertain to the wills and estate. Just give us a brief overview. Kuthiwani mase khuluma ngama wills nama estate?
Yeah. I realized that in the locations, for an example, Soweto, more than 70% of properties currently are not registered in the names of people who inherited those properties, because after the death, the beneficiaries are not following the procedures to go to master's office and re-register the property to an executor or a beneficiary. So after 10, 15 years, because now they are experiencing, hello, are you still there? Can everyone hear me?
We can hear you loud and clear, sir. Thank you.
Okay, thanks. So they start now realizing after 10, 15 years that they were supposed to approach master's office and re-register their property. It's either to an executor or to a beneficiary, meaning that an executor is not the owner of the property. It's someone who has been appointed to administer the property on behalf of the beneficiaries. And if the beneficiary is taking over, meaning that the property will be transferred from the previous owner to the beneficiary. So the beneficiary is not an executor, it's the person that will own the property. So they realize after a very long time that they have been sitting or staying in the property for years and years, and no one is accounting, because you will also find that they are not even paying the rates and taxes. So come 15, 20 years down the line, the property is owing the municipality. Whether they sell the property or not, they still have a challenge because they are not owning that property anymore. When they sell, the municipality will have to claim the cost. And maybe the cost is, for an example, 120,000, and the value of the property is 240,000. So already they are owning the property that doesn't belong to them. So those are the problems that we have in the locations. So it is very, very important for people to know after the death, immediately they have to approach the master's office, all the beneficiaries, so that they can appoint an executor. Executor, the four of you, if you are siblings, as beneficiaries, you can be all appointed as executors, or only one person can be appointed as an executor. So that is the challenge currently that we are having in the locations.
Thank you, Brother Lucas. Let's make it practical. All right. Victor Sibeko, Mrs. Sibeko, three sons. Okay.
Yes.
The two sons are over age, 19 and 21. Then the youngest is 12. Now, in
Yes.
this instance, if I don't have a will and I pass on, what are the challenges?
We have what we call Interstate Succession Act that kicks in immediately after the death if there is no will. So meaning that master's office will call all the beneficiaries for them to appoint an executor. The executor will be the one that will look after the estate of the late, and all the beneficiaries will be given an opportunity to decide who will be the executor, as I said before. But yes, whether there is will or no will, at the end of the day, someone has to account on that estate. The problem is that when the family has no idea that after the death, they have to report an estate to master's office. That's where the problem is.
Okay. Now, the moment you touch the master's office, you don't just walk into the master's office, and that requires some representation and some legal guru. You have shared with us your basic knowledge from your practical experiences on day-to-day basis. Now, Mr. Mugwena, in your space, here is a situation where a family has been torn apart because the father died. There's the mother and the children left. And within that, you know, with us, with some families, the husband's families will now want to come in and claim that this is our son's house. Where now you are a Makoti, you came Kadihumu, and then you must go back. Now, from the legal perspective, Mr. Mugwena, in your understanding, just share with us what is the proper way of handling these these hiccups and these challenges when it comes to wills and estate. What is a will legally from your side when you stand there and you say your learned friend and your wash? Just give us your legal perspective. Wills, estate.
Yes, an estate is divided into two. There is a testate and interstate succession. The testate succession is when someone has passed on, having left behind a will which meets the formalities that are required by the Act. I will deal with formalities later. And then in the interstate succession is when a person has died or passed on without leaving behind any will. Then if you have no will, then it means the Interstate Succession Act will kick in by the operation of the law. And then when you approach, immediately when a person has passed on, the families will approach the master's office. They will be advised that your estate worth more than 250,000. Therefore, you have to appoint an attorney who is going to assist you in reporting the estate to the master. Then, if there is a spouse married in or out of community of property, that spouse will be given a preference to be appointed by the master as the executor of the estate. If the spouse is not there, then the children who are left behind uh, will be given an opportunity to appoint one of each other. There's a form that they have to fill and append their signatures to say, we appoint so and so to be the executor of the estate. They can appoint two executors of the estate. They can appoint even four. The problem is that if there are many, it becomes difficult when it comes to that accountability. Remember, we're dealing with an estate which must devolve amongst all of them. And then there won't be any accountability to say that in the late estate account, there was so much money. Was it distributed or not distributed? One of them will have to account to the master. It is always advisable that they appoint one person to be the executor of the estate. Let's take a scenario whereby Mxolisi Mugwena is married and then he has two children. Then the Mxolisi Mugwena, the wife and the children, they die in the same accident. Then what's going to happen to the estate? The estate will go down to the grandchildren if there are grandchildren. If there are no grandchildren, then it goes to the parents. If there are no parents, then it will go to the brothers. The master is there to make sure that the estate goes to the right person. We have seen on several occasions whereby one of the family members will approach the master to say, no, I'm the only one left in the family, they're all dead. Then the master will require that person to produce death certificates of all the people that he says they have passed on. May I pause, Babu Sibeko?
Yeah, it's rough. Okay. I don't want us to be the ones that are really hunting and going on and discussing this. I think for the moment, I'd like to pause and open up the floor for everyone to understand. But just to sum it up, what I'm picking up from the conversation is that when we leave, we must have a will. And if we have a will, we make life easy. And I think that can piggyback from the opening quotation that I shared, that a will is not just a legal document. It's a love letter to your family, ensuring their well-being and security after you are gone. Now, the will has to be drafted. And we see these adverts and offers, people saying we can draft a will for you, but there are certain things that are not shared in terms of what happens after you're drafting the will, because the will becomes that special document which will protect your loved ones when we are gone. Now, if we don't have a will, this whole mess ends up at the masters. Then for me to have access to the masters and understand everything, I'll have to get Advocate Mugwena to assist me, and that is money. And while I'm working the path of getting myself sorted out and assisted in resolving the issue around my will, there's infighting within families. So without a will, we are exposed to a whole lot of things, of which some of the people even dump, and they don't care, they don't bother following that up. And apparently this money goes into some government trust or something that sits there, and we don't know who gets it and who does not get it. And now we are left with a family that is struggling. Children are unable to go to school and finish the school. The house is owing money. In certain instances, Tate Lucas will help us. A house is attached, and there's a whole lot of other corrupt activities that take place. Whereas if we have a will, in that will, we would have stipulated what we would like to share to who and how. And in this instance, it's all guided, it's all clear. But without a will, the money can even end up on people that you do not even wish to have a cent or a penny of your money. Now, this is Kekhomi Mshate. Waihapa umulatu, wailisa umulatu. So we need to thoroughly understand. But before I spoil it, I'll allow our guests to throw a spanner in the works. And if there's anyone that has had a good experience or a nasty experience, please share with us, so that we are able to, through your question, we will be able to assist others. I would like to share something very, very, very sad, that before we started this meeting, someone dropped in a message to say, I don't want to go back to this topic again because I've been dealt a serious blow. I've been hurt so much with the issue around the will. Up until today, I have not even received a cent from my departed husband. So it is a serious issue. So we need to get over it, and we need to get it right. Let me pause right here and make this interactive, because we are having a conversation. Anyone who would like to weigh in the conversation, ask a question, share the experience. You can also say you want to ask about the property, speak to Lucas, or you want to ask about the legal matters and speak to Advocate Mugwena. We're still going deep. We're going deep. There's more to discuss. Right? The floor is open. Any takers? Comments, question?
Thank you very much. I think before we commence with the testate and interstate succession, it will be imperative for us to discuss the matrimonial property system.
Okay.
Marriage in community of property, out of community property without accrual, out of community of property with accrual. Those marriages, the types of marriages or matrimonial property system, play a vital role in the estate, in the deceased estate, especially when you are no longer there to answer for yourself.
Correct.
So before we go into the interstate and testate succession and all those things, the master will look into the marriage certificate of that person to see whether that person is married in community of property or out of community of property, whether there is a what is called antenuptial contract, so that when the will is when the estate is distributed, the master will know precisely whether the spouse is entitled to 50% of the estate or not. Because let's take, for instance, the value of the estate is 10 million, and you are married in community of property. The first 5 million go to the spouse in terms of marriage in community of property. The spouse is not inheriting, is entitled by the operation of the law. Then if there are, let's take for instance, 3 children, that money will be divided into 4. The spouse is still going to inherit what is called a child share, is going to inherit the equal share with those children. And then when that is done, that is when the estate will be winded up by the executor who shall have been appointed. I think we are going haphazard. The most important thing to do is to deal with interstate succession. When we are done with interstate succession, then we enter into testate succession, then we proceed. I'm not sure if I'm correct, but I think that will make our lives easy. If we touch testate, interstate, and other things, we are going to forget a lot of things that are important when it comes to the law of succession.
Wow.
Before I proceed, I want to introduce to you Dr. Tshidi Lelaka. She's on this platform. She's a friend of mine. She's a senior lecturer at Wits University. Thank you very much.
Oh, thank you. Thank you so much. Welcome, Dr. Lelaka. We've already had a brief conversation before you joined in. Advocate Mugwena, I was thinking that I'm allowing the guests to throw a spanner in the works. You've just thrown in Bobo Jan, the biggest spanner that is masters that can untie any nut, any size nut. Perhaps you can then take us into that, but maybe I might have sharpened somebody's appetite in terms of saying your comment, your question, before we get to that. But if there's none, we'll go straight into what Advocate Mugwena has shared with us. Okay. Abu Lucas?
Questions were going to assist us to, focus on the challenges that people are experiencing. Because we gave them the background of what is all about wills and estates. So, yes, the concerns will guide us, and we will be more into the challenges than explaining the whole process of how it should be done. And
All right.
if yes, indeed, if there are no questions, unfortunately, we will have to now start the process from the beginning until to the letter Z, meaning that as Advocate Mugwena has mentioned, that we have to start where we should start than cutting pieces, because we will not have the juice of this whole project that we are working on.
All right. Thank you. Thank you so much, Baba. We do have one hand for comment. Let's take that. Bonkosi. Bonkosi. We cannot hear you, but it's all is well. You are unmuted, but we cannot hear you. Okay. Well, while we're trying to find Bonkosi, I see Untabi saying is also trying to, I don't know whether he's just trying to set up or trying to come to unmute. Untabi? Okay. This takes us then to what Advocate Mugwena was saying, the strategy, because that is very important. Where do you start, and when is the best time to start working on the issues around the wheel? But before we get started, before we open this up, I've had a
Good
question.
evening,
Oh
good
yes,
evening.
yes,
I
yes,
hope nangizwa.
Siyakuzwa
Nangizwa.
baba. Siyakuzwa manje, yes sir.
Nangizwa.
Yes, we can hear you.
Do you hear me?
Yes, we can hear you, because
You can't hear me.
we can hear you. Siyakuzwa.
Check here. Do you hear me now?
Siyakuzwa, yes.
Do you hear me now?
Yes, yes. We can hear you. We seem to be having a challenge with the Broncos. Okay, all right. There's a terminology that we often use. We say we'll take it from the top. Advocate Mugwena. I think for one to have a will, it starts off when I am married. I have a wife. Now I need to make sure that when I'm gone, my wife does not suffer, or I don't leave her in a desperate times. Then I've got children. What happens when I'm gone? What happened to my wife and my children? Now, before I allow you to take us through the whole strategy, I had a question in my inbox that says, what happened in a situation where a parent has passed on without a will, and the parent leaves 3 properties? But in all these properties, there's what we call permits in the old townships, and in these houses there's permits, and in each and every one of these houses, there's somebody that the parent appointed to say, when you look after this, when I look after this, when I look after this, but there's nothing in writing per se. And now the parent is gone, and the best thing to do is to sell these properties. But then the family that's left is battling to sell these properties because there's a lot of other documentation and questions that are being asked, but there are title deeds to this parent.
If there is no will that has been left behind by the deceased parent, then the law of interstate succession will kick in by operation of the law. What's going to happen is that they will look into, first of all, whether the deceased was married or not. If the deceased was married, then they will look into the matrimonial property system that he elected when he was still alive, on the day when he got married. If it is married in community of property, then the next question is the spouse still alive or the spouse is deceased? If the spouse is alive and there are children, then the estate will devolve around the spouse and the children. The spouse, as I indicated, will be entitled to the first 50% of the entire estate. Whether in those properties there are caretakers, or people have been appointed by the deceased to take care of those properties. Remember, they are not entitled to anything unless they are his children. Therefore, 50% to the spouse, then the remaining 50% will devolve around the wife and children. Then when that is done, they will approach the master to say, so and so has passed on. There are forms that are going to be filled by the person who will be appointed by them, an attorney or an advocate with trust account. I'll explain later what does it mean to have a trust account as an advocate. Then that person will fill those forms and state to the master, confirm to the master that the deceased was indeed married. The deceased was married in community of property to Margaret or to Maria. Then that Maria, because there is no will automatically be appointed as an executor of the estate unless the spouse says, no, due to the kind of illness that I have, I'm not prepared to assume the position of the executor of the estate. Then that's when they will choose one of the children, or the attorney himself can be appointed to be the executor of the estate. I am sitting with a scenario whereby one of the professors died without a will, or there is a will which we don't know where it is. Then the wife, he left behind a wife and a child. So this wife at the moment is suffering from dementia. She's not even aware that the professor has passed on. So what do we do under these circumstances? It's either we appoint the attorney, we apply to the master to appoint the attorney as the executor of the estate, or we approach the court to be appointed, to appoint the attorney or one of the children as what is called a curator ad litem. A curator ad litem is someone who runs the administration of the estate. That person must be an attorney. If that person is not an attorney or an advocate, then that person will be a curator bonus. And then when a curator bonus is appointed, then that curator bonus will be able to administer the estate, the deceased estate, because the person who is fully entitled by law to be the executor of the estate cannot be able to do so due to maybe the illness such as dementia, or suffered from stroke, or any other ailment which will make it impossible for that person to assume the position of the executor of the estate. Then the estate is reported to the master. The letter of executorship will be issued. What is the significance of the letter of executorship? This letter of executorship is very important. It's as important as marriage certificate. You know, when you are married to someone, you've got a power to control the estate of that particular person because you are married. So as an executor of the estate, in the first place, you have to place an advertisement in the newspaper informing the world that so-and-so has passed on. We want to wind up his estate. If there are people who are indebted to this estate, let them come forward so that they can make payments. But more often, those people don't come forward. Instead, the creditors, such as SARS, such as Standard Bank, if there's a house which is being owned, or such as, for example, Bradlow's, Edgar's, those are people who will come forward to say, yes, this person is owing us so much money. So before you do anything, you must start by paying those people, and then the residue is the amount that is left when the debts of the estate have been paid. So this residue is the one that will devolve around the heirs. Why do we call them the heirs? We call them the heirs because they are beneficiaries of the estate, because there is no will. Can I stop here for now and wait for questions?
Yeah, I did say that it's murky, it's rough. Folks, the only way we can get cracking and be able to clear some of the concerns that you may have and questions is to allow you to comment, and then we can get get to the crux of the matter, where we want to understand ubaba, umama, abantwana underage, and the significance and the importance of e-will. How do we deal with that? Okay. Any comments?
Yeah, I would like to add on what Advocate Mugwena has just said now. Not
Mugwena.
only,
Okay.
yes, Advocate Mugwena, am I right?
Yes, sir.
Yes. Yeah. Not only the companies can claim on the estate, even the individuals, as long as you can prove that the estate is owing you, and then you can approach the estate and claim what is due to you. Thank you.
Yeah. So the program Wankolo, I can work here. I can go say you owed me money when you passed on.
Yes. Yes.
Yo, it's rough.
So
It's rough. It's rough. Okay, let's take another hand from Pinky. That's my sister all the way from London, the UK. And Pinky.
Okay. My question to the advocate is, I got a bit worried when he shared about the scenario where the lady has dementia and therefore she's deemed not having capacity to do or say anything within his belongings or his or her belongings. I wanted to know then that the law in South Africa, does it not then consult the mental capacity legal side to establish whether the person has mental capacity to make any decisions? Because it is said that a person must be assumed to have capacity unless it is established that he or she lacks capacity, and a person is not to be treated as unable to make decision unless all practicable steps to help him or her to do so have been taken without success. And that now brings in the medical team or the mental health team with their legal body to see if this person has capacity or not, and let not this person be erased as non-existent because of the mental health condition that he's presenting with.
Very, very interesting angle there. And I'll tell you why Pinky is so passionate about this. She's an activist and she's a nurse by profession, and she represents the voiceless. She's the voice of the voiceless. Very interesting question. I think Mr. Mugwena, if you have come across a situation like this where somebody's ability is questionable, I think we've lost Advocate Mugwena. Yeah, we've lost him. Okay. All right. Mshengu has a question. We will take it from Walter Mutaung's gadget, or where Lucas is. Mshengu, sondela baba.
My question was, let's say both parents has passed on, and before the children can appoint the executor, what's the duration time behind them to organize themselves?
I don't know whether I can answer that one.
Okay. We'll appreciate.
Yeah. Immediately after the death, you must approach the master's office, because the estate is owing, meaning that if there are properties, someone has to keep on paying the responsibilities like the rates and taxes. If there is bond, someone must keep on paying the bond. So immediately after the death, the estate should be reported to the master's office.
Yeah.
Thank you.
This is real tough. This is real tough. Now, ladies and gentlemen, you realize then, why is it that when the parents have passed on, their children left, and all of a sudden those children will be homeless? Or if there's a husband that passes on, then the wife all of a sudden has to pack the things and go back home, vice versa, and the same can happen to the husband. So, with this just brief conversation that we're having right now, we can see the complications of this issue around not having a person not having a will. Let's see if we can get Advocate back. But while we're waiting for Advocate Bongenkosi, you've got your hand raised. Acknowledge you. Go ahead. Unless it was a legacy hand. I would say a legacy hand, the hand that was raised from the last time. It's still up. All right. Any other questions or comments before we move on? Okay, Mshengo?
Yes. Let me ask. Okay, when a situation whereby our father has
Just get closer to the mic.
attorney.
Just get closer to the gadgets, please.
Okay. Our father has appointed an attorney for his will. But now, when we went after he passed on, and then we went to the offices, we found that they said, before they can read the will for us, we must pay a certain fee. Then that certain fee, it was already including the fees for the house to execute everything that my father has owned. But now we're not happy about it. Up until today, we've never given a chance to hear what was on the will. So how can you help us?
Okay.
Are we forced to use them, or can we choose an attorney that will be in our favor?
All right.
Okay.
Okay.
Yeah.
All right.
Sorry, Mr. Diego.
Okay, Lucas.
Yeah. Let me put it this way. Immediately when someone passed on, the estate must be reported. And when you report the estate, then there will be an executor. So the executor will claim 3.5% of the value of the estate. That is what is due to an executor. And as the executor, sometimes they are not experienced when coming to administering the estate. Then it's where they will appoint someone to administer that estate. So attorneys, maybe I can leave that one to Advocate Mugwena, but according to my knowledge, they will have to claim from that 3.5%, not in advance, unless otherwise. But according to my knowledge, 3.5 covers all the cost to administer the estate.
Okay.
So meaning, according to my knowledge, those attorneys, they were not supposed to ask for money in advance. They were supposed to claim it from the estate, from that 3.5. If there was an executor, they were supposed to discuss with the executor that we are claiming, maybe we are charging this amount of money to administer this estate. And then if the money is within that 3.5%, because that's the law, you cannot claim more than 3.5% of the value of the estate. And then that's how it was supposed to be conducted.
Okay. Thank you, Lucas. As I said, it's getting murky, it's getting dirty, and there's more to come. You realize how important it is to be well informed about this matter. Tupi? Esther?
Good evening, gentlemen.
Yes, sir. Can we see you? Yes.
Yeah, no, thank you. My question is, in the will, what must be written? What must be in there? If I have a fridge of beers there, must I include how many beers are in the fridge? Or I need to get that clear. What must be written in the will so that we know how the will works as well, because it's something that I've experienced with one of our friends who passed on. He made a rough sketch of a will, and when we took the will to the attorney, they said that will is not properly written because it doesn't state what is what and how much was that and all of that. Now I think I need clarity on that one.
Okay. All right. Thank you. Thank you, Esther. I think that you've asked a question for everybody else will benefit from that answer. And we've got Advocate Mugwena back in terms of what needs to go onto the wheel. Let's wait for Advocate to come in. And welcome Tula Gumede. Welcome. Thank you for joining us this evening. And Sibongi Lesi, I thank you so much for being very active. We also have a comment on the chat. I will share that later on. Indotonga item now mbuzala, and the question is, what exactly must go on the wheel? Because someone had a draft and then they pass on, and the draft was taken to the attorneys, and it was regarded as non-existent. The question says, do I also put ukuthi no bobi injayam ne fridge ne bottle lami le John Walker Blue likhona lapho uma ngihamba liyakubala. Legally, the process and the procedure you will. And then the next question would be around a family with a will going to an attorney or advocate to get assistance in terms of reading their will, and the attorneys requiring or requesting upfront payment before they read the will. So those are the two questions we have.
Yeah, thank you very much. When you draft a will, first of all, you must state your names that are reflected in your ID, then the physical address where you stay, and then from there you must appoint the executor of the estate. Prior to the executor of the estate, you must revoke all the wills that you drafted before. Let's say today is the 4th of March 2025. All the wills that were drafted by you prior to this date must all be revoked. Why is it important for you to revoke all these wills? At some stage, you'll have two wills that are contesting with one another, whereby someone will say, no, I know Standard Bank has got my father's will, other one, Net Bank. And so these wills will be contesting. In order to remove the confusion, all the wills that you have ever drafted before must be revoked. Then from there, after you have appointed the executor of the estate, let's talk about the executor of the estate. The executor of the estate can be any person of your choice that you think will be able to carry out this function. You are not obliged to appoint your spouse, because maybe at some stage when you draft this will, things are not going well between you and your spouse, or they are going well, but you feel there is Victor Sibeko is better suited to be the executor of the estate. It's your will. Remember, a will is what comes from your heart. No one can dispute it as long as it is in line with formalities. So the executor of your estate must be over 18 years of age. which means he must have a capacity to act. Remember, if you appoint a 14-year-old, that 14-year-old won't be able to open what is called a late estate account, where your monies that will be collected from various places will be deposited. And then from there, you state that you are married to so and so in community or out of community of property, with or without accrual. Those things should be stated in the will, so that you cannot have people who are not entitled to benefit from your estate coming forward to say, I was married to so and so. Remember, we are Africans. Kunale ithembu zomkokotelo ezingaziwa. So kuzovela omunye umama athi awangikhiphela amalobolo wenzani. So you must state in your will that I am married to so and so. From there, then you can distribute your will that I bequeath my 50,000 rands to my son so and so. I bequeath my house to so and so. I bequeath 2 million to African National Congress. I bequeath 11 million to SPCA, whoever you want to distribute, to bequeath your money to, or whatever you want to bequeath to those people, you are at liberty to do so as long as it is stated in the will. One other thing, some of us, we originate from the rural areas, from the former homelands. You must state in your will whether you want to be buried in Katlehong or Chowoza, or you want your body to be buried Kodi Rapeng Tsabageshu Kasipid, where you'll be buried with your ancestors to be appropriate. And then from there, you state to the master that whoever will inherit from your will must not put forward what is called a security. People, the beneficiaries must inherit free from putting some security. And then when you are done doing that, there must be witnesses who must sign in front of you, and that will must be signed in front of the witnesses. Then underneath your name, there must be your ID number, the witnesses' names, and the ID numbers, so that the day the will is contested, it should have witnesses. I have seen quite recently, when people draft their wills, each and every page they sign, and the witnesses sign each and every page. It's not compulsory. You are the one who's supposed to sign each and every, to initial each and every page. Then at the end of the will, at the end, when you have stated everything that you want to say in your will, then that's when you put your signature. Then the witness will sign after you. Thank you.
Thank you so much for that breakdown, Advocate Mugwena. And these days, there are templates online for you to go through, and also depends which banks you bank with, that they can assist you with that. But it is important for you to get proper advice as to what happens after that, because you can go to whoever and have your will and signed, and then your will is stored, which I'm going to throw that question back to Advocate. When the will is signed, it's all done. That will has to be kept in a safe place. And there's a lot of other things that happen with the keeping of the will. Advocate Mugwena, what are the do's and don'ts and of keeping the will after having signed it?
Right. Remember, a will is a document that will talk to you the day you are unable to talk. So it must be kept in a safe place, in the attorney's offices. quite recently, there are these companies who are being appointed to keep documents. So your attorney will arrange for you so that your will should be in a proper storage, but you'll be paying a certain amount. More often, it's 60 rands per month for your will to be kept there, so that when Mugwena is dead, your will must not die with you, with him. Your will must continue to speak for you when you are unable to speak. There's a case in Bloemfontein whereby Standard Bank kept a will on behalf of the testator. A testator is someone who have drafted and signed a will. And then this testator felt that 50 rands was a lot of money for him to pay to the bank for storage. He decided to store the will in his house. Upon his death, someone from the family pick up that there is a will and their names are not there. Then the will disappeared.
Oops.
And the bank could only offer a copy of the will, and it becomes more expensive for the beneficiaries or the legatees, because they must approach the High Court for the declaratory order. They must, they will have to secure those people who signed the will, actually the witnesses, to come and depose to the affidavits to confirm that this the will was signed in front of us on such and such a day. We were witnesses. Then you approach the court, the High Court, for the will to be to the copy to be made valid. If there's a court order, then that's when the master will accept the copy. But the master will warrant you to produce an original will, not a copy. But if there is a court order directing the master that indeed the court is satisfied that this is purported to have been a will of the testator, then it will be accepted. Remember, you died 3 months ago. Money was spent to bury you at 150,000. I don't know why are we doing that as Africans these days, but it's a choice of the family. If they want to give you a good burial, they can spend so any amount, it doesn't matter. Then they have to approach the court, and the lawyers don't come cheap. If you want to approach the High Court, you're going to spend nothing under 50,000 for that will to be validated by the court. So it is better to arrange with your lawyer, make a payment on monthly basis. Your will be kept safe by the companies whose duty is to keep very important documents. And one other thing, I have a problem with these wills that are drafted by banks. In the first place, when a bank drafts a will for you, you are not given an option to appoint an executor of your own choice. More often, it becomes the bank trustees who become the executor of the estate. When you are dead, then the bank will appoint an attorney of their own choice. The attorney that you'll see for the first time as a heir or a legatee. And then that attorney will take his own time. There's nothing that you can do. And with these white law firms, if there is a four-roomed house, yes, a Meadowlands, worth 270,000, and there are 10 grandchildren, and there is nothing to benefit from that estate, then they how can I put it? They withdraw or addiate. I was avoiding to use the word addiate. Yes, they addiate to stand as the executors of your estate because there's no money. But if there is money, let's say you are a principal of a high school, there is money from pension or there is an investment, and when they look at your will, they realize that there is something to benefit because the executor in law is entitled to 3.5% of the estate. So they'll be able to generate 3.5% of your estate. Then that's when they become excited. But if there is nothing, they just withdraw and give a will to the beneficiaries to appoint any attorney of their own choice. And these children, remember, more often they don't have money. The economy is bad, so they your estate won't be dissolved timelessly because there is no money. That's more often that's what I've seen.
Yo, no, go rough. Go rough. I did say it's gonna get rough. It's gonna get rough, and it is rough indeed. Okay. Let's just hear. Let's get dilute this conversation. It's been men. May I invite? I saw Mrs. Beko's hand is up. Mrs. Mrs. Angola, Madam Jules, Donna.
My name is Mrs. Sibeko, and thank you for this. The invitation, Mr. Sibeko, for me was so important because I think the topic speaks to my soul, my heart, and everything, because I'm currently in a situation where the lot of things that we didn't do correctly, probably because we didn't know what to do when our mom died, which was 20 years ago. Till this day, I don't think anyone thought of going to the Master of High Court to report her death. So, and she had two properties, one in Orlando East, one in Orange Farm. And this is the moment where I wish I could say I'm asking for a friend, but I just have to be honest. That is the issue that I'm faced with. We are currently trying to see how we can correct what we didn't do due to the fact that we didn't know what to do at that time. So we have the property in Orlando East where my sister and her children are staying, which we don't have a problem. We regard that as a family house. Anytime I want to go home, she opens her hands and heart to welcome me. But the issue is with the property in Orange Farm, where before my mom died, there were people that were staying in that property, and they've tried a lot of mischievous things to try and get that property onto their name, but thanks God they failed every time they tried. So eventually the girl is trying to secure that property in the right way, where she is engaging with us to see how she can buy the property from us. But and I think maybe a lot of people, we are in trouble because of what we don't know and what has not been shared with us, especially the Black people. I'm sorry, I don't want to sound like I'm talking down on Black people, but there's a lack of information, and I'm talking for myself, because when the property now is being occupied by those people, they're not paying rent. We don't know if the rates and taxes are being paid, and now she wants to buy it. And we now find out that we have, or we should have then reported my mom's death to the Master of High Court. It's just a mess. So in a nutshell, I'm asking, in a case like this, what are we supposed to do?
Okay, Madam Sibeko, thanks for the question. Advocate Mugwena.
It's not a train smash. In terms of the law, you have to report the estate to the master within a year. But due to some reasons which best known to the family, you can still report the estate even after 20 years. All what you need to do, you need to organize the ID copies of all the beneficiaries, then and check if there was a will when the parent died. If there was no will, which means an interstate succession will pop in, then we'll be able to report the estate to the master. And then what is important for you to do is to transfer the ownership of those properties to the right beneficiaries. And it's either you transfer them to the grandchildren or whoever you think will be appropriate to take care of that property, or you create a trust with the master where those properties will be administered by the trustees for a particular period. The danger of transferring the ownership of those properties to our children is that let's assume you are left with two girls and there are two properties. Then at some stage they will share those properties. And then Omunya Suga get married to a Nigerian guy in community of property. So immediately that property become the joint estate. And then when it's a joint estate, 3 years down the line, they divorce, then that property will have to be sold. Then, and they will have to share the proceeds. That is the only danger. But it's very important to transfer the name. Remember, the title deed cannot have the name of the deceased person, a person who died 20 years ago or 10 years ago. Definitely, it must be owned by a person who is still alive. Mr. Sibeko has my contact number. We can assist with that aspect. But it's very, very important for you to do. It's not too late. You can report that to the master anytime.
Okay.
Thank you.
Thank you so much, Mr. Mugwena. You just stolen words out of my mouth. I know your office in Pretoria, opposite the Supreme Court. I'll come running to get this done. It's about time we get this right. Let us just take a question from the comments section from Bonginkosi. Bonginkosi says, let's say Bonginkosi is married to Mrs. Bonginkosi and they both have an accident and they had no children. However, the wife have parents. The husband doesn't have parents, but have brother and sister. Does that mean that only parent of the wife will get the estate?
When we started, I said the matrimonial property system which the parties entered into will play a pivotal role when the estate is being wound up. If the parties were married in community of property, then 50% will go to the parents, then 50% will go to the brothers, the remaining brothers, if they are married in community of property. And then if they are married out of community of property, egwakho, negwame, egwame. So the brothers will only inherit what belongs to their late brother, and the parents will inherit what belongs to their daughter. Kulapho kungena khona ukuthi mawushonile ifamily icashe ikhumbi, icashe ivan, mayifika lapha ithola ukuthi bekukhona isponge nesithombe se-Orlando Pirates kuphela, kunanix. It happens quite often. Endaweni eziningi. You are married out of community of property, and then the whole estate belongs to the wife. The wife says, "No, I've got invoices. I bought all these furnitures. Now you have my invoice." There's nothing that they can do. kune out of community of property with accrual. Sorry, the house that you bought or whatever you acquired before you enter into nuptials, before you got married, it belongs to you personally. But what will accrue during the subsistence of the marriage then will belong to the joint estate. Law and Zoku kwakha nobabili. Let's say ngeyi-4 zaka March wena bowunezindlu eziyi-2 ozithenge before ungene emshadweni. Lezo zindlu lezo kuzoba ezakho wena personal if you are married with accrual. Then from ngeyi-5 ukuyalena, whatever you acquire with your spouse will belong to the joint estate, including the pension fund. Pension fund that you acquired from ngeyi-5 ukuyale muva, it does not form part of the joint estate. It is the only one which will form a part of joint estate is the one that you will acquire after you got married, and then the contract stating that there is accrual. But if there is no accrual,
Yeah, this is rough. This is rough.
So the matrimonial property system that you elect when you get married is very, very important. Don't enter into it before you consult with an attorney or someone who is knowledgeable when it comes to the matrimonial property system. It's very, very important. And then before we proceed, these days, young people get excited, organize the uncles, write a letter to the prospective in-laws, then arrange, sit down, pay so much money in terms of lobola, that is in terms of our customs and traditions. Then there is this letter which will be written, ireceipt yabo nombongeni Ngema, where basho ukuthi abakazibani bahlangene nebakwaSibeko ngelanga elithile ukuzocela ubuhlobo obuhle bakabani bani. That letter is very, very, very important. The day you pay lobola, even if you can pay 100 rands, you must know very well that you have entered into the customary marriage in terms of our cultures. I was reading a certain note like that today, where the deceased paid about 1,600, but that was a long time ago. In 1999, he paid 1,900, and that was a lobol. That letter can be used because you have entered into a customary marriage and it's recognized by law. Then, in the event that you dissolve your relationship with your spouse, that letter will be utilized, and estate yako will be divided equally. So the best way to do it, you must decide whether you want to enter into an in-community of property or if you don't want to enter into an in-community of property before a prenuptial contract where you consult a notary public. There's a lawyer called the notary public dealing with contracts, with the registration of contracts. That person will guide you, then draft the contract. By the time you go and pay lobolo, the contract is now in existence. There is a judgment, a recent judgment, where they say these people paid lobolo. They entered into the customary marriage. And the customary marriage, remember, is in community of property because it's meant to protect lo mama umshiyele enatali alibela kugadela abantwana anganalutho. Then when you divorce that person, then akasena next. So a customary marriage is meant to protect them. It's automatically in community of property. So even if later, this is a bad law in my opinion, even if later you can choose to enter into a civil marriage out of community of property, the fact that you entered into the customary marriage, your marriage automatically is in community of property, then your antenuptial contract is not recognized. It's a recent judgment of Pretoria High Court, of which I think the Supreme Court of Appeals may come into a different conclusion.
Thank you, Advocate Mugwena. It's continuously getting rough and rough and rough. Okay. If you allow me, may we also have another voice from a lady, Mage Tuli Gumete. Over to you, Tuli. Tula. Pardon, Tula.
Yes,
yes ma'am.
thank you so much for this topic. It's really an important topic, especially for us Black people, as Mama Shilo earlier on. This is a subject that I can say we've never spoken about. It's new to us. So I just want to ask a question. We now know what there are templates that are online, so you can go to Google and then you can download a template of which you can use for your will. And because money is not our strongest thing as sinayo thina njengabantu abamnyama, we want something that can also work for us. So if I were to use the template, because I don't have money, for an example, for now to go and consult with the lawyer who will actually assist me and my husband to draw this will, how will it then work if we use that template that we have downloaded? So we write everything, we appoint an executor, we do all the things that the form actually is guiding us to do. Then what will be the next step for us to do with that particular form? If I may get a clarity on that, I'll appreciate it so much.
Thank you.
That will, if it's an original document and it's written and it meets all the formalities as prescribed by the law, there will be no reason for the master not to accept that document. But I advise you to forget about it. I will draft a will for you the day you come to me. Don't worry about the money aspect. I'm here for that. I'm chosen by God to assist you.
Wow.
I'm not sure if I've answered you.
Wow.
Thank you so much. Thank you for that. Thank you so much.
Wow. Sure.
Yeah, but the danger of that will, remember, when you draft a will, you must state in your will that whoever will inherit any of your estate from this will, in the event that they get married in community of property, the inheritance will not form part of the in community of property.
Yes.
They will belong to them personally. That's a very important clause which you must include in your will. That's what I do. So that I consulted, I think it's a year ago, with a lady who brought a will. Yeah, when I look at that will, I find that clause. That clause will prevent you. There's nothing that you do because this house belongs to him personally. It's not part of the joint estate. It's a very, very important clause. And there are a number of things which are not included in that template. So it is imperative for you to consult with a lawyer. Don't worry. I won't charge you an arm and a leg. When you consult a lawyer, the consultation fee is 2,005. Imvula mlomo yamalawyer le. Ungakakhulumi. Then they will charge you 5,000 rands for a will, which means you must have 7,500, which we don't have. So if you have an estate that you think it needs to be regulated in the will, you can come to me. I will assist you. I won't charge you anything.
Ngizawonga uJehova ngelinye ilanga.
Wow, we're so humbled. Advocate Mugwena, and I think this platform and this opportunity and this conversation today, it came from Utando nje lwabantu, and you are just demonstrating that the angels are not far-fetched, and they don't fly up in the sky in the clouds with white slippers and wings, but we've got angels here. I think so. Some of us who may be able to also reach out to you and get you to assist us. We would really like to do that and support. If you've made an offer to one, does not mean you have to make an offer to all of us, unless otherwise I put a
Sorry
challenge
for
to everyone.
interruption.
Yeah.
Sorry for interruption, Mazia.
Yes, ma'am.
All what you are going to do, you are going to pay for a storage on monthly basis of 40 rands or 50 rands. I'm not sure how much do they charge.
Okay.
That's all what you are going to pay for, so that it will be safe in the. You'll have a copy if you wish to keep it in the house. If you don't wish to keep it in the house, you can keep it in the lawyer's office if you want to. But that's the only amount. And if 50 rands is neither here and there, okay, for your estate to be protected.
Wow.
But if when I feel like I love 50 rand now, it's fine. We will keep it for you. But the day which a building, you are not going to you are not going to blame us. Quite recently, I've realized that Jehovah is Scorpion, Hawks are investigator. Sekuchama buildings amaningi eJoburg, and those buildings that are burning, the fire is meant to conceal evidence. So kuzosha newili yakho lapho.
Yeah, thank you so much, Ms. Mugwena. Folks, there you have it. Whilst we at it, I've added the contact numbers of Advocate Mugwena, as well as Abuti Lucas on the chat. Thanks, Marek Komete. You've just opened up an opportunity for all of us to see it good, to go and review our wills and see what we need to do and support Mr. Mugwena, and also get the help we need. We only have 9 minutes left. May I suggest that maybe next month, let's have this conversation, but let's take it from the top. The marriages, the types of marriages, and everything else that goes with marriages, because that's where the problem is now. Abonkosikazi bephepha, abonkosikazi basemakhaya, and then iy'ncanakazana, nalaba bavela sekonakele ukuthi nami unkosikazi bafike bakhale kakhulu uma sesihambile thina obaba. I think we need to have this conversation. Yeah.
Abo baba angazi base bangenwe yini kulamalanga. They have a tendency of absconding from matrimonial home. Ahamba yohlala nomunye umama, ahlale for a period of 10 years. Sorry. Ubaba makasahleli lena wherever eMzumbe or eMeadowlands. Nalo mama lo usalu yashona wena ngapi. You guys are still married in community of property. Who's going to be the executor of the estate? The executor of the estate, uzoba ulo baba lo uhlala nomunye umama le eMeadowlands. And makafika athathe yonke imali yabantwana ahambe naye lena athengise nendlu leyo ukuthi bahlala lapha ayisafuniye. So those are things that we should guard against. And then kube nale ithembu lezomkokotelo where you are married in terms of civil marriage, mara ngapho uyahamba uyokhipha amalobolo elsewhere. And labayana banayo incwadi yamalobolo. And they believe that the lobolo letter is valid. Unbeknown to them that if you are married in terms of civil marriage, you cannot enter into a polygamous marriage. And ngapha umntana kulotsholiwe kunezingane. The day you die, you should know that the marriage that will prevail is civil marriage that was entered into prior to the second marriage. Or alternatively, there is this negligence amongst us where you enter into a customary marriage and you don't see any need to go and register that customary marriage if you think it's appropriate for you. Nisasenale ncwadi yamalobolo mawusesebhizi nencwadi yamalobolo useyahamba ubaba uMgwena uyolobola enye intombi le eNewcastle aphinda ashade naye in terms of civil usala nale ncwadi yakho. The marriage that will prevail ileyana until you go to court to invalidate the second marriage to say mina ngilotshole ecala. Omunye I have a case whereby this brother paid lobolo on the 26th of March is an example, and then divorce with the first wife was actually finalized June, and ngapha he has paid ilobolo. Lo mama lo wamalobolo lo believe ukuthi yena is customarily she's married, and then immediately you die avele lo athi hayibo mina mabakulobola ngalezo 3 zakamatsha I was still married to this guy, therefore your marriage is invalid to the extent of its invalidity, and there's nothing that you can do. I have invalidated a certain marriage 3-4 years ago, a marriage enjengaleyo. So whenever we do things, we have to do things properly. One other thing that we did not address, Babu Sibeko, corner is joint will, the mutual will.
Yeah.
Those in our next interaction, we have to address that as well. Where Umamu Sibeko and Babu Sibeko, but teenagers, mostly we are comfortable, we are happy. Why not having the same will in one document?
Yeah.
Then it will state that this is a will of so and so on so and so, where you appoint each other in the event the other one dies. Then omunye uzoba i-executor of the estate, then lo munye uzobenefita uzoshare i-estate nabantwana in terms of the will. Ehlupha kuphi ke, the day you die in the same accident or nishele endlini, that will is likely to be invalid because angithi ikhetha one of you to be an executor.
Yeah.
And then one other difficulty that I've seen, if you die in the same accident, let's say I bequeath my estate to Ubaba Sibeko. Umama Sibeko bequeath the estate to Ubaba Sibeko, and Ubaba Sibeko vice versa. Then they die in the same accident. And then these other people who are supposed to inherit from them will have difficulties because now we need medical evidence to prove ukuthi kushone bani kuqala wasala bani ubani inherit komunye, but it happens once in 10 years. Akusiyo into ehlala yenzeka, but those are things that we have to check and talk about. Thanks.
Yes, thank you so much. We only have 2 minutes, but within these 2 minutes, we've got these 2 questions to answer. We lost you after Opinki has asked about, after you shared the story about the lady who was incapacitated, who had dementia. Now, Opinki wants to find out, would you please touch on the subject of mental capacity and the legal rights of the individual so affected? Dementia does not discriminate. Someone may find themselves in the situation.
No, it doesn't discriminate. Actually, when the court appoints someone else to administer your estate while you're still alive, it's meant to protect your interest. More often, they appoint a lawyer. That is called a curator at the team. That person will have a legal expertise. He knows what to do, when to enter into the contracts on your behalf, when to protect. That person will report to the master from time to time. And the accountant will have to be appointed. When the accountant is appointed, that accountant will report to the master as well to say, no, imali zalo muntu letsese right, uziphethe kahle. And then if you are not a lawyer, but you are a family member, you can be appointed as well. You can approach the court or approach the master to be appointed. It's called a curator bonus. So that curator bonus uzokhona run and as a bank figure, you'll run the accounts as alo muntu lo who's unable to take care of his own or her own estate due to mental incapacity. Konote curator bonus is why.
It sounds very nice. Okay. There's a comment from Kefilwe, and she says that she's heard that a will can be contested. To what extent can this be?
More often when they contest, you contest formalities that 1, 2, 3 were not mentioned in this will, or the signature is not the signature Yagamove. But if you contest the signature, then you have to bring you take that will to the expert. Uzokala a check lo J S I uyafana na law oku handwriting Yagamove na or ku signature Yagamove, and then bese ayasho ukuthi no, this signature is fake. Then the will be set aside. More often amongst African people, we contest isn't as in generals.
Okay.
Or remember, you cannot take a person suffering from dementia or mental illness or who is in mental institution, is a will. Those are things that the requirements that you can challenge. Okay. There are so many things that you can challenge in the will to be set aside. Or, for instance, John Mudise's will, bebatate itamb by Begela Payan. Equity no, a person who used to sign a legislation, Yamasoja, it means begangaboni nokutsokwenzakalani. Tatele inki na ikobisa lapayana and tate itupa na ibe. Therefore, it can be set aside. Or the wording of the will itself can render it invalid. Iwilia White says, I bequeath my estate to my daughter so and so, who will be unborn at the time of my death. It was in a critical state, knowing very well that it can die at any time. So Lomtana Lona was born, and then the whole estate was supposed to have gone to this child. It transpired, Mabayenza paternity test, Lomtana Sewak. Then the whole will was set aside.
Oh my
and
goodness.
Invalidated by the court.
Hey, good
So, Kunzim.
Kunzim. Okay. It's 9 o'clock. I know we started late. Tammy has just joined us. Welcome, Tammy. I would like to take a hand from Meadowlands and Brotherhood. Buti, over to you. Quickly.
Dumelang. My question, I don't know if it's a question or just a comment about the recent case here, the king. The king recently, apparently, married another wife, and there's a contest around that. So I just wanted to comment or question, is it possible that since the king is the custodian of customary law, how possible is the court? I'm thinking the king overrides over such legal matters in terms of the legalities of marriages. One other comment also, as well, as you said, customarily, if you are married, automatically the marriage becomes community of property. So meaning the constitution recognizes our customary law. So I was so surprised last time when our king was taken to court. You remember the Dhaka smoking king. But according to a constitution, as the customary is recognized, our king was not supposed to. So I'm saying sometimes our legal institutions, sometimes they don't recognize our constitution and our customary law. So I just wanted your comment around that.
Thank you very much, my brother Lolo.
Lolo. Yes, thanks, Lolo.
Yeah, let's start with the marriage of Mrs. Zulu. Mrs. Zulu, King Mrs. Zulu, Kazweltini, made a big mistake by getting married in terms of civil marriage. Remember, a civil marriage cannot coexist with polygamy. So I think there was an agreement between him and his first wife to say, let's go and file for divorce so that we can enter into a customary marriage and register it. Because in law, if that customary civil marriage is still in existence, all these other customary marriages will be invalid. All of them, even if they can be 20. So he wanted to remedy the situation, in my opinion, but I'm not sure. Remember, lawyers don't use guesswork. They prove beyond a reasonable doubt. And then Yaga King, is it Buyelekaya Dalinjeb? Are you referring to him?
Yes, sir.
Yeah. In our constitution, the constitution says there will be, it says the constitution shall be a supreme court of the land. All acts which are in conflict with this constitution shall be invalid. And it continues to say everyone shall be equal before the law. It doesn't say the kings will be more equal or less equal before the law. So if you violate the law as a king, you'll be taken to prison. King Buyelekaya, what happened is that he presided over a case of a stolen livestock, then were pronounced a death sentence, of which in law he's got no powers to pronounce a death sentence, of which we don't have. So then he was charged with the attempted murder. That's how we went to prison. So the principle of equality before the law. Oh, thank you.
All right, folks, I don't want to be a bad boy. I think when we started, it seemed like we all over, but we had so much to deal with. And the way we say when we want to eat an elephant, to eat it piece by piece. So we started off with the trunk, and as we were carrying on enjoying the trunk, I had to take a little bit of an ear, but the conversation got so deep that somebody wanted us to go for the hut. The elephant is too big. We still have so much that we need to deal with. There's one question. Donna, Mama Sibeko, quick one before we wrap up.
Hey, that is work. You can't keep saying Donna Julian. I'm not that old.
In Portuguese.
But thank you very much, Advocate. Thank you, my brother who is in Meadowlands, Mr. Lucky. Thank you so much. I think in Tatasbeko, there's a lot that we would have wanted to ask, but of course, cat is the enemy right now. And my suggestion is there any way that maybe Mr. Lucky and Mr. Mxolisi can maybe arrange another session and just to recap from what they've discussed with us. I think I have a lot of questions, but of course, it's not on my side. Because I also wanted to ask about or maybe understand more about family houses. How do we deal with that? Because my perception right now, or what I've heard, is if we are 5 and my 2 brothers have passed on, their share would then be transferred to their children, which I don't think is correct, but anginalo ulwazi. So that's why I wish we could have another session where we just recap and see if from this session there were other questions that we wanted to ask. Because of time, we couldn't. I'm just asking for Ukuthi, if you can arrange for that, it will be highly appreciated.
Okay, thank you, Masbeko. So the last will and testament and trust, because we didn't even touch on the trust. We have the return in conversation. The return, Baba, last will and testament.
Yeah, my suggestion, because this gadget, you know, we are not, some of us, I'm a computer, so I found them quite well. So, what if we arrange a venue anywhere, even if Kula Pubakona Bololi, we'll go there, go and address corner where we'll have enough time, spend a day. There are so many questions that you guys need to ask. For instance, some people think that a life cover, the funeral cover are part of disease estate, and of which they are not, because when you buy a life cover, you appoint the beneficiaries on the spot. And then they say, if in my life covers, you nominate my sister or my mother to be the beneficiary, umama wasekhaya wahlanya, or uyibone ekhaya entwena ke monna waka, or I'm not going to release a letter of executorship, the ID akamufi, or any other document efunakalayo. So those are issues that we have to iron out so that we are very clear whenever we do things. Even the formalities of drafting a will, sizikenje phezulu, azange saya deep, because nje zinama complications was at times. Do you remember the police woman Rasuche from Pretoria, from Mamelodi, who was killed and buried by Nkuna?
Yes.
Yes.
And that's whether you remember that case.
Yes, we do.
Yeah.
In the period of 8 years, you can't wind up the estate yalo muntu lo because he has disappeared. And unama policy, unomuzi, unani, the insurance can't pay because there's no death certificate. What happens under those circumstances? Those are things that we have to talk about so that when you are confronted with such situations, abantu baya disappear, guys. Rox Dlamini disappeared. We don't know his whereabouts even today. And Rox Dlamini, remember, he left behind a house, a wife, children, cars, money in banks. So those are things that are issues that we have to deliberate on.
No, thank you, Mr. Mugwena. It's we've got 2 minutes to wrap up because we started 1:15. And to those of you that have joined us late, sorry that you're only catching up now. About the meeting, yes, indeed. I think a live meeting will do well. I mean, we may have to raise a sponsor to have some teas and coffees, and we have a plenary session that will be followed by a Q&A panel discussion. Then we have a Q&A. We need to have these conversations, and most of these topics are very disruptive because some of them will be rubbing people the wrong way. But we need to get to that level, all right? Before I close, I saw Masbego's hand up, and just before I declare closure, I see the hand up again. You have the last word, Mrs. Sibeko.
Before ngikhuluma kakhulu, I'm so excited about the meeting le ubaba ayisuggested. And if it can be ngesikhathi ngizobe ngila ekhaya, I can sponsor some cocktail things.
There we go. We've got a sponsor. Yay!
Be back next week.
Okay. No, we'll plan properly. We'll plan properly, and it's important that we get a consistent
on time so that ngizokwazi ukubuya from Angola.
Yeah. All right.
Okay.
No,
No. What about
thanks.
the UK?
The person in the UK. No, you come on.
It
Okay,
will be
we'll
a
wait for you.
live one, and you'll spare a room for the virtual one.
No, we'll do hybrid. We'll do hybrid. While we live, we'll also
Technology is
broadcast
advanced,
it. Yeah.
guys. You can't dump us.
We'll
We
do a
are
hybrid.
at
All
home,
right.
Masilapo.
Okay. Thank you so much.
We'll courier some eats to you, my cousin.
Okay.
Yeah. Okay, Bra Lucas. I know we delve a lot on the legal aspects, and there's a lot on the property side which we will have to deal with when we have another session. Can you give us your parting shot from this conversation?
Yeah, it was very informative and very interesting. I would just like to add on what Advocate Mugwena has said. When coming to wills, the beneficiaries cannot witness. So that part, it's very, very important for people to know that you cannot be a witness on the will if you are a beneficiary. But I'm very happy, and yeah, I'm here forever. Thank you.
No, thank you so much. Yes, sir.
Can a spouse be a witness in the will or a nominated executor? Those are things that we have to talk about, but Lucas.
Yes. All right.
True.
Okay. I will be doing
sorry, Babu Sibeko.
Yes, bro.
But Lucas, in a situation whereby two parties are not married, they decide to buy. I decide to buy a house. Then later I include what is called baby mama in the title deed. Is it possible to remove her later if I feel like?
You are asking me?
I'm asking you.
Unfortunately, you will have to buy her out. You can, but you have to buy her out.
Okay.
It will not be for free.
Okay.
Right, there's so much. All right, folks, watch this space.
Thank you very much. It's a crucial question.
Right. No, thank you so much, folks, for this. Babu Mugwena, your parting shot.
Thank you very much for inviting me. It was a very crucial and very informative interaction, particularly with the subject that I like. It has got a special place in my heart. I've seen particularly educated people and uneducated people becoming victims of circumstances in life. One day I was watching the show Gugitilana. I saw a house of a guy that I knew who was a high school teacher, who was a friend of mine, being a center of dispute. And I felt very bad. That's when I developed love for Ama Wilson Estate. So let's take this subject very serious. I'm here to assist you. I will assist you. And apart from Ama Wills, even if you have other legal issues, I will assist you as long as ungangizeli no auntie kagogo kasisi wasesinawane ovelelwe yini. I will have difficulties, but members of this group, maybe with their spouses, I will ask.
Thank you so much, much appreciated. I would be doing injustice not to invite Uslupi to have a word. Slupi San, the founder of the Brotherhood. Slupi, your parting shot. Sibongele baba, sibongele kuindwendwe zethu.
Babu Mugwena, Babu Letsholo, Thank you very much. Thank you. Ngiyacabanga this thing we must take it on again. As Sibeko ngiyacabanga ashilo nabanye abomama. Ngibonge kakhulu. I'm happy, guys are happy as well. I'm with other guys here and they all happy. Looking forward to the next session nalento. Ngibonge kakhulu Mazia, sibongile nakuba Shabalala ngokusihosta as he always does. Angapheli moya.
Okay.
Sisonke kulento.
Thank you very much, my brother. My advice to you, this church must grow. It must go to Orange Farm. It must go to Sebokeng. It must go to Katlehong. It must go to Davidton. It must become a very big church.
Yeah.
Thank you very much.
Thank you so much. Yeah, we say we are brave hearts because we use unconventional methods to reach out and talk about things that matter. You know, guys go to the tavern or to the pub to drink, but on a special day, we close the tavern, no drinking, but we talk about real matters that matter in life. So we really appreciate that, and I think I would be doing injustice if I don't ask Tshidi Lelaka to say, you know, just please bless us. Bless us with your wise words, Sisemse Nwako, and we really appreciate having people like you, so humble yet so effective in their space. Metsidi? And now put you on the spot. She unmuted and muted.
Yeah, maybe she's struggling with the gadget.
Yeah.
I'm not sure how so, because they use these things every day.
Can you hear me?
There we go. Yes, we can.
Yeah. No, thank you so much for great insight. I just want to concur with you that our communities needs these types of conversations. So we're so used into witnessing our communities and families fighting for assets, you know, and we have the knowledge and the information just next to us. So we need to use this information to leverage on the best informed choices. So if we can make this information as widely as possible, as easily and accessible as much as possible, and to make people aware that they have power themselves. The power is in themselves, and we undermine ourselves so much because we don't use that opportunity and we're pointing fingers. So there's just too much drama. We're known for bad things that when somebody dies today, 24 hours later, there's just too much drama in families. The uncles fighting for the benefits, the assets. I can go on and on and on. So we've seen this from our neighbors. We've read this in newspapers, and it continues to happen even in 2025. So we're not expected to behave like this. So let's use this information to help our brothers and sisters and different families as much as we can. Thank you so much.
Thank you so much. Much appreciated. And to everyone else who've joined us, much appreciated. Compromising your time for your data, but also your presence means a lot because together we grow. This conversation will be uploaded on YouTube. Just if you go on YouTube tomorrow, you go and check Brotherhood in Conversation. Brave Heart in Conversation, Brave Heart Brotherhood in Conversation. We will upload it, so it will be forever there for you to go and revisit and watch if you need to remind yourself of something. So that we will announce the next session soon, but we would like to have such conversations and on Tuesdays, because that's when we all have the guys relaxed and not too busy at the bar and having this worthwhile conversation. But I see Mage Gumete. I promise you have the last word, my dear.
No, I wanted to ask something, Baba Sibeko, is that if you can send us the link on the WhatsApp group,
okay,
so that you can be able to go straight there. Thank you so much.
Okay, ma'am. Thank you so much. I will do so. On all the platforms where I shared the invitation, I will share the link as well. Thank you. Much appreciate. Good night. Matonga Mandi, hope to connect with you soon. We will make announcement of the next session. The same time, I will start looking for. I think we need a bigger, proper venue, like an auditorium or a nice hall where we can all sit, and with good Wi-Fi connectivity, we can also make it hybrid so that people who are unable to come through or who are not in Soweto, like Pinky in London, and they can just join in that. Ngiyabonga, Kamandi, good night.
Thank you very much. Good night.
Good night.
Mm-mm.
Night.